So the respondents herein were arrested on the 18th day of July, 2023, just a day before the planned demonstration called by the leadership of Azimio led by Honorable Raila Amolo Odinga. I take judicial notice that the intended demonstrations were declared illegal by the National Police Service. The respondents herein have been described as influential members of the society working with the county assembly and the county government of Nairobi. So the application is following the arrest. The respondents were arraigned in court on the 20th day of July 2023, where the applicant filed a notice of motion application undated, seeking for the respondent to be detained in custody for a period of 14 days to allow the applicant to complete investigation in respect to the offenses of conspiracy to commit an offense, contrary to Section 393 of the Penal Code, preparation to commit an offense, to wit, and lawful demonstration and riots, contrary to Section 78, as read with Section 79 of the Penal Code. Thirdly, being in possession of firearm without a valid firearm certificate, contrary to Section 42A, as read with Section 43A of the Firearm Act, and organizing public meeting and procession, contrary to Section 5 subsection 11 of the Penal Code of the Public Order Act, among other related offences. The application is supported by the grounds on the face of the application, and they are supporting affidavit of the lead investigator, Inspector John Kariuki Munjama. The application was vivaciously opposed by a battery of advocates representing the respondent. They were namely Ms. Kemuma, Mr. Nyaberi, Mr. Kwanga, Mr. Ochich, Mr. Bigambo, Mr. Wanyaga, Mr. Kokebe, Mr. Ayora, I hope I got it right, Mr. Ogado, and lastly, Mr. Omari. The lead investigator, Inspector Kariuki, in cross-examination by the respondent's counsel, stated that the substratum of his evidence against the respondent is from intelligence report, which he could not disclose, of course, by dint of Section 133 of the Evidence Act, Cap 8 laws of Kenya. He contended that at the time of the arrest, the second respondents were found with a firearm without a valid license, and that the same was not registered. It is further his contention that the firearm in possession of the second respondent was previously used to commit offenses. He also considered that the respondents cannot interfere with investigation with the various agencies, namely the Firearms Bureau, the Cybercrime Unit, and the mobile service provided, namely Airtel and Safaricom. He also reiterated that the respondents are influential members of the society, and therefore they will interfere with witnesses and evidence. He stated that they were all arrested before the planned demonstration. He further stated that the witnesses are yet to record statements, and they are unknown at the moment. And they also pointed out they were arrested in eateries in different places in the city. So accordingly, when the prosecution presents a suspect for purposes of seeking them to be held in custody to facilitate conclusion of investigation, the prosecution must, in the application to court, be in accordance with Article 49(1) G and H of the Constitution. There has to be a justifiable reason for the continued detention of the arrested person, and that there are compelling reason for refusal of bail. The right to liberty and freedom is a fundamental right that is inherent to every human being. Article 29 of the Constitution recognizes this fundamental right. So the Constitution has put in place safeguards in the Bill of Rights to protect the right to liberty. The right to liberty is sacrosanct, and it is the fundamental freedom upon which other rights are enjoined. For instance, without the right to liberty, one cannot enjoy the freedom of association, the right to privacy, and the freedom of movement and residence. The lead investigator considered that no witnesses has come forth to record a statement to date. In my view, the respondents cannot interfere with witnesses whom even the investigating officer does not. So in view of the foregoing, I find that the prosecution and the investigating officer has not laid before this court compelling reasons to have the accused person deny their constitutional right to bail. So the upshot of which, I hereby dismiss the application and have the accused person admitted on bond or bail. I'll proceed to grant the respondents, the first to the sixth respondent, bond as follows. They may be released on a bond of Kenya shillings 300,000 with the surety of a similar amount, and to the alternative a cash bail of 200,000. So a cash bail of 200,000 and a bond surety of 300,000.